Hello! We're going to be going through some more history of patents in the USPTO. We have to go back to 1331 to start understanding the concept of patents. John Kempe, I apologize for the misspelling, it should be Kempe, was a weaver of woolen cloths. He was from Flanders, and he wanted to enter England with his men and exercise and teach his trade freely under the king's protection. This case was by no means unique, and he was granted permission from the king that was very obviously intended to be precedent, giving assurances as it did that other men of the same land could be expected to have rights of protection should they choose to ply their craft in the realm of England. Moving forward about a century, this was more formalized in letters of patent. These letters were issued by the sovereign, the king or the queen, and it protected inventions. So you had an invention, it would be presented to the sovereign, and he or she would grant you a letter of patent protecting your invention. The U.S. Constitution, Article 1, Section 8.8. The Congress shall have power to promote the progress of science and the useful arts by securing, for limited times, to authors and inventors the exclusive right to their respective writings and discovery. This was important enough to be in our U.S. Constitution. Now, the U.S. Patent and Trademark Office was created by an act of Congress, but it falls under the executive agency, meaning it's under the purview of the president. So let's see how it fits in. In 1952, the law was passed that the United States Patent and Trademark Office was established as an agency of the United States within the Department of Commerce. So it's the Commerce Secretary of the President's Cabinet that oversees this federal agency. Now, in carrying out its functions, the USPTO was subject to the policy direction of the Secretary. Everybody has to have a boss, but otherwise retained responsibility for decisions regarding management, administration of operations, independent control of budget, expenditures, personnel decisions, processes, procurements, and other administrative and management functions. That was a lot of power for a government agency. And those operations were designed to grant and issue patents, and those operations which are designated to facilitate the registration of trademark, and that each of these shall be treated as separate operating units within the USPTO, meaning that you're not going to have a mixture of trademark examiners and patent examiners being in the same organizational unit, because a lot of what they do is very different. Continuing on, the United States PTO shall maintain its principal office in the metropolitan Washington, D.C. area. for the service of processing papers and for the purpose of carrying out its functions. They're actually in Crystal City, which is in Virginia. Now notice the word service of process. The patent agency can get sued, and you have to know where the process takes place and the papers and summons and so forth need to be served properly. The PTO shall be deemed for purposes of venue in civil actions to be a resident of the district in which its principal office is located, except where jurisdiction is otherwise provided by law. If you ever take a class in corporate law, you'll realize that a company is a citizen of both the state in which its headquarters is in and the state in which they are incorporated. For purposes of this title, the USPTO shall be referred to as the Office and the Patent and Trademark Office. Now, things happened between the writing of the Constitution and the 1953 law. Patent law was actually covered in the revised statutes of 1874, and those were originally derived by the Patent Act of 1870. So the U.S. has a very long history of protecting inventions. Finally, I just want to talk again about international issues. The Patent Cooperation Treaty. This is used to protect patent rights outside the U.S. And for countries that are part of this treaty, a general single filing electing those countries will act as a filing in all those countries. So if you want a patent in Germany, a patent in Italy, a patent in England, you just file with one of those countries and ask that it go through the PCT. Filing is very expensive. Each one of these checkpoints are thousands to tens of thousands of dollars. So if you're going to attempt to get a patent in a foreign country, it's important that you determine the value of having that patent there versus not, and also the amount of enforcement that country gives to intellectual property patents. Some are very good, some are less than good. So, this has just been a very brief introduction to the history of patents. Thank you.